Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute legal, financial, or professional advice. Divorce laws, mediation regulations, and procedural requirements vary significantly across different states and jurisdictions within the United States. Individual circumstances, including local court rules and specific case facts, can drastically alter potential outcomes. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified attorney, certified mediator, or financial professional in their specific area before making any decisions regarding their legal rights, assets, or family structure. The average litigated divorce in the United States today can easily exceed $50,000 in legal fees and take upwards of 18 to 24 months to resolve in a backlogged court system. Yet, there is a statistical anomaly hiding in plain sight within the American legal landscape. Historical trends suggest that when couples step out of the courtroom and into a mediation suite, their chances of reaching a full settlement often soar above 80%. Imagine a system where the success rate is not just a coin flip, but a near certainty for those who engage in good faith. We are currently witnessing a massive shift in how the American family unit dissolves, moving away from the scorched earth litigation tactics of the late 20th century toward a data-driven, interest-based negotiation model. This is the hidden history and the hard math behind divorce mediation in the U.S. In this deep dive masterclass, we are going to dismantle the myths and look at the raw numbers that define the mediation industry. For the modern American taxpayer and parent, the stakes have never been higher. By understanding the historical success rates and the structural reasons why mediation works, you will gain a clear perspective on how to navigate one of the most complex financial and emotional transitions a human being can experience. We are solving the problem of information asymmetry, the gap between what the high-priced litigation industry wants you to believe and what the actual historical data says about efficiency, cost-saving, and long-term compliance. To understand where we are, we must look at the statistical great shift that occurred in the 1970s. Prior to this era, the United States operated primarily under a fault-based system. To get a divorce, you had to prove a wrongdoing like adultery or cruelty. This created a statistical bottleneck where only the most aggressive or the most wealthy could navigate the system. When California passed the Family Law Act of 1969, effectively inventing no-fault divorce, it triggered a litigation explosion. By the mid-1970s, the U.S. court system was drowning, judges were overwhelmed, and the data showed that adversarial litigation was actually increasing the likelihood of post-divorce conflict. This is where mediation entered the statistical record as a pressure valve. In 1976, legal scholar Frank Sander proposed the idea of the multi-door courthouse at the Pound Conference. The hypothesis was simple. If we sort cases by their complexity and the relationship between the parties, we can solve them more efficiently. The historical data from the first pilot programs in the early 1980s was staggering. In states like Florida and California, early mediation programs showed that nearly 75% of participants were able to reach a total or partial agreement without ever seeing a judge for a final trial. Let's look at a concrete case study of how this data translates to the real world. Consider the historical trends of a mid-market divorce in a city like Atlanta or Denver. In a traditional litigation model, two opposing attorneys might bill an average of $300 to $500 per hour. Between discovery, depositions, and pre-trial motions, the burn rate of the family's net worth is exponential. Statistically, for every $1 spent in mediation, couples in the U.S. have historically saved between $4 and $6 compared to what they would have spent in a fully litigated trial. This is not just a minor saving. It is a fundamental preservation of generational wealth. The success rate of mediation is often cited between 70 and 90%, but we need to look deeper into what success actually means in a statistical context. In mediation research, success is measured through three primary lenses: settlement rate, participant satisfaction, and long-term compliance. The settlement rate is the most obvious metric. Historically, about 82% of court-ordered mediations in the U.S. result in a signed agreement. However, the satisfaction data is where the story gets interesting. Surveys conducted by organizations like the American Bar Association and various state court systems consistently show that parties who mediate feel they have more procedural justice. They feel heard, whereas in a courtroom, a judge might only give each side 15 minutes to present a year's worth of grievances. The third metric, long-term compliance, is perhaps the most important for the U.S. audience today. If a judge orders a father to pay child support or a mother to follow a specific visitation schedule, the relitigation rate, the chance they will end up back in court within 2 years, is significantly higher than if those same parties had negotiated the agreement themselves. The historical data suggests that when people have agency over their outcome, they are statistically more likely to follow the rules they helped create. In some jurisdictions, the relitigation rate for mediated cases is as much as 50% lower than for court-imposed orders. But why does the math favor mediation so heavily? It comes down to the information exchange efficiency. In a courtroom, information is weaponized and filtered through the rules of evidence. This is a slow, expensive process. In mediation, the statistical model shifts to a transparent exchange. Instead of spending $10,000 on a forensic accountant to catch, espouse, mediation encourages a voluntary disclosure model. Historically, this reduces the time to resolution from an average of 18 months down to just 90 days in many U.S. states. We must also address the power imbalance variable. One of the most common critiques of mediation in the 1990s was that it might disadvantage the less powerful spouse. However, longitudinal studies over the last 30 years have shown that with a certified mediator who utilizes specific balancing techniques, the outcomes in mediation are statistically comparable to court outcomes in terms of asset division. The difference is the emotional tax. The data shows that the stress levels, measured through self-reporting and even health outcomes in some academic studies, are significantly lower for those who avoid the adversarial nature of the witness stand. As we move through this 10-part series, we are going to look at the regional variations across the U.S. We will see why states like Florida became mandatory mediation pioneers and how that impacted their judicial economy. We will examine the rise of private judging and how it intersects with mediation statistics. We will also dive into the pro se revolution, the growing number of Americans who are using mediation to bypass attorneys entirely, a trend that has grown by over 30% in the last decade, according to census data and court filings. The problem we are solving today is the fear of the unknown. By looking at these historical trends, you are no longer a victim of a confusing system. You are an informed participant in a well-documented process. You are seeing that the viral horror stories of divorce are often the statistical outliers, the 10% that refuse to settle. The vast majority of the American experience with divorce is moving toward this mediated, collaborative model because the data proves it is simply more sustainable for the family and the economy. This is only the beginning of our deep dive into the numbers that define the modern American divorce. To understand the weight of these statistics, we have to look at the granular reality of a typical American couple in the year 2026. Imagine a couple named John and Sarah. They live in a suburban neighborhood outside of a major tech hub like Austin or Seattle. They have 2 children, a primary residence with a significant mortgage, 2 401ks, and a small side business. Historically, if John and Sarah chose the path of litigation in 2026, they would be entering a system that is fundamentally designed for conflict. The legal fees for a contested divorce in a high cost of living area are now trending toward an average of $300 to $600 per hour per attorney. When you factor in the paralegal fees, the filing costs, and the expensive expert witnesses required to value their side business, the initial $10,000 retainers are often depleted before they even reach the discovery phase. The potential outcomes in this scenario are statistically bleak. In a litigated environment, John and Sarah are essentially delegating the most intimate details of their financial future and their children's schedules to a judge who may have less than an hour to review their entire life history. The data shows that this disconnect leads to a high rate of dissatisfaction. However, when we look at the case studies of couples like John and Sarah who opt for mediation, the numbers shift dramatically. Instead of 2 competing narratives, the mediation process creates a single collaborative data set. In 2026, many mediation firms are utilizing advanced financial modeling software that allows couples to see real-time projections of their post-divorce budgets. This transparency is a key driver behind the 80% success rate. When both parties can see a clear path to financial stability, the biological impulse to fight often gives way to the logical impulse to settle. The historical trends of the last decade have shown a massive spike in what is known as the settlement gap. This is the difference between what a party thinks they will get in court versus what they actually walk away with after legal fees are deducted. For example, in a litigated case, a spouse might fight for 2 years to get an extra $50,000 in assets, only to realize they spent $70,000 in legal fees to win that battle. This is the sunk cost fallacy in action. Mediation addresses this by putting the financial reality front and center from day one. In many U.S. jurisdictions, the data suggests that mediated settlements are reaching a level of financial parity that mirrors court orders, but without the massive overhead of the adversarial process. Let's break down the step-by-step details of why the success rates are so consistently high. It begins with the initial intake. Statistically, the mere act of agreeing to mediate is a strong predictor of a successful outcome. It signals that both parties have moved from a position of retaliation to a position of resolution. In the 2010s, mediation was often seen as a last resort before trial. By 2026, it has become the primary entry point for the majority of domestic relations cases in the U.S. This shift is partly due to the emergence of the mandatory mediation movement. Over 30 states now have some form of required mediation for custody disputes. The historical data from these programs shows that even when mediation is forced by the court, the success rates remain remarkably high. This suggests that the process itself has a transformative effect on the participants' ability to communicate. One of the most fascinating statistics in the history of U.S. mediation is the efficiency of the caucus model. This is where the mediator separates the parties into different rooms and shuttles back and forth. Research into negotiation dynamics shows that this model reduces the emotional noise that often sabotages high-stakes deals. In a 2026 context, this often happens virtually. The historical trend since 2020 has shown that remote mediation via high-definition video conferencing has actually increased settlement rates in some demographics. The data indicates that being in the comfort of one's own home, rather than a sterile law office or a high-tension courthouse, lowers cortisol levels and allows for more rational decision-making. We see a direct correlation between lower stress environments and the willingness to make the necessary concessions for a final agreement. Consider the historical timeline of the mediation industry. In the 1990s, the primary focus was simply on clearing court dockets. Success was measured by how many cases were removed from the judge's calendar. Today, the metric for success has evolved into what we call the durability of the agreement. A study of over 500 mediated cases compared to 500 litigated cases showed that the mediated group had a 40% higher rate of child support compliance 3 years after the divorce. This is a crucial data point for the U.S. audience because it proves that mediation isn't just about getting to a signature. It is about creating a functional roadmap for the future. When parents co-author their parenting plan, they have a psychological buy-in that a court-imposed order simply cannot replicate. Furthermore, we must examine the role of time to resolution as a primary success indicator. In the current 2026 legal landscape, the U.S. court system is still dealing with the ripple effects of structural backlogs. A standard trial date might be set 18 months in the future. In contrast, the average mediation process is completed in 3 to 5 sessions. This time saving is not just a matter of convenience. It is a matter of mental health and financial preservation. The historical trends show that the longer a divorce drags on, the more likely the parties are to engage in high-conflict behaviors that permanently damage their co-parenting relationship. Mediation effectively freezes the conflict and moves the parties toward a resolution, while they still have some degree of goodwill left. If we look at the historical trends across different states, we see that California, Florida, and New York have pioneered different statistical models for mediation. Florida's model, which relies heavily on court-certified mediators, has consistently shown some of the highest settlement rates in the country, often exceeding 85% for family law matters. This is largely because the state has integrated mediation into the very fabric of the legal process, creating an expectation of settlement rather than an expectation of trial. In 2026, we are seeing other states adopt these best practices. As the data becomes undeniable, the economic impact is also significant. The reduced burden on the public court system saves taxpayers millions of dollars annually, which is why we see such strong bipartisan support for mediation programs across the U.S. But what about the cases that don't settle? Even in the 20% of cases that do not reach a full agreement in mediation, the statistics show a significant narrowing of issues. This means that even if a couple can't agree on everything, they might settle 8 out of 10 items on their list. This reduces the eventual trial from a 3-day ordeal to a 2-hour hearing. From a statistical standpoint, this is still a massive success. It minimizes the legal spend and ensures that the judge only has to decide on the most complex or entrenched disagreements. The case studies of these partial settlements show that the parties still benefit from the reduced hostility that mediation provides. As we continue this masterclass, we have to acknowledge that the math of mediation is not just about dollars and cents. It is about the human capital of the family unit. The historical data regarding children of mediated divorces suggests they experience fewer long-term behavioral issues compared to those in high-conflict litigated divorces. This is the ultimate success of the process. We are now seeing the first generation of children whose parents used mediation in the early 2000s entering adulthood, and the longitudinal data is beginning to show a clear trend of better emotional resilience. However, as effective as the math makes mediation seem, there is a hidden psychological architecture that can either cement a deal or blow it apart in the final hour. While the numbers are overwhelmingly positive, they depend on one invisible variable that most people completely overlook. In the next part, we dive into the invisible third party and the psychological triggers that often dictate the outcome of the entire negotiation, and how knowing them can shift the probability of a successful settlement even further in your favor. The invisible third party is rarely a person standing in the room, but its influence on the historical success rates of U.S. mediation is profound. In the professional world of conflict resolution, we define this as the shadow influence of external stakeholders. Imagine a scenario in 2026 involving a couple named David and Emily. They are sitting in a virtual mediation suite, attempting to divide a complex portfolio of crypto assets and a primary residence in a high-growth market like Charlotte, North Carolina. On the surface, it is a two-way negotiation. But statistically, there is a third party present: Emily's father, who is a retired litigator, and David's new partner, who is encouraging him to stand his ground on the vacation property. Historical trends show that the presence of these outside voices can drop the potential for a settlement by as much as 30% if not managed correctly. This is because the invisible third party is not privy to the nuanced concessions made during the session. They only see the final numbers, often through a lens of protectionism or personal bias. To counter this, successful mediation in the U.S. has evolved to include specific protocols for managing these external pressures. Mediators in 2026 often use a technique called reality testing to bring these shadows into the light. By asking David and Emily how their respective influencers will react to a specific proposal, the mediator forces the parties to acknowledge that they are negotiating for themselves, not for the approval of their social circle. This leads us directly into the first major psychological trigger that dictates the math of mediation: loss aversion. This is a concept rooted in behavioral economics which suggests that for most Americans, the pain of losing $100 is twice as potent as the joy of gaining $100. In a divorce context, this translates to a statistical obsession with what is being given up rather than what is being retained. If Emily feels she is losing 20% of her retirement to David, her brain registers this as a high-threat event, triggering a fight-or-flight response. Data from the last decade of family law research indicates that when a mediator frames a proposal in terms of loss, the rejection rate is nearly 70%. However, when the exact same proposal is reframed in terms of gain, focusing on the liquidity Emily will have to start her new life, the acceptance rate flips. This is the structural reason why mediators spend so much time on interests rather than positions. Positions are what you want, interests are why you want them. By shifting the conversation from a loss-based model to an interest-based model, mediators are able to bypass the amygdala and engage the prefrontal cortex, which is where rational long-term settlements are born. Let us look at a case study involving the endowment effect, which is another psychological hurdle that historically lowers settlement rates if left unchecked. The endowment effect is the tendency for people to overvalue something simply because they own it. In 2026, we see this frequently with high-value personal property or tech equity. Imagine David has worked at a startup for 6 years and holds significant stock options. To the market, those options have a volatile but specific value. To David, they represent 6 years of 80-hour work weeks and personal sacrifice. He values them at a massive premium over their actual liquid value. In a traditional litigation model, an attorney might feed into this overvaluation to keep the client happy, leading to a costly battle of experts. In mediation, the statistical approach is different. The mediator introduces neutral third-party data, historical market trends, and independent valuations to decouple David's emotional attachment from the financial reality. The success of mediation often hinges on this specific step: the normalization of value. Once David sees that his overvaluation is a documented psychological bias and not a unique personal insight, the probability of him reaching a settlement on those assets increases by nearly 50%. Another critical trigger is reactive devaluation. This is a phenomenon where a proposal is automatically rejected or diminished simply because it originated from the other party. If Emily suggests that David takes the house while she keeps the liquid accounts, David might instinctively think, "Why is she offering this? What am I missing? What is the catch?" This skepticism is a primary driver of stalled negotiations. The historical data on U.S. mediation suggests that the mediator's most powerful tool against reactive devaluation is the use of the caucus or the private meeting. When a mediator takes Emily's idea, refines it, and presents it to David as a neutral option or even as the mediator's own suggestion, the rate of acceptance skyrockets. This is not about deception. It is about packaging information in a way that the human brain is actually capable of processing without the interference of past relationship trauma. Statistically, proposals delivered through a neutral intermediary are evaluated more objectively than those delivered across the table. In 2026, many virtual mediation platforms even have built-in features to facilitate this blind proposal method, which has historically led to a 20% increase in early-stage settlements. Then we have the sunk cost trap, which we touched on previously but must now examine through the lens of psychology. By the time a couple reaches mediation, they may have already spent months in a state of conflict. They have spent time, emotional energy, and perhaps thousands in initial legal fees. The brain's natural inclination is to justify that spending by winning. Historically, the most successful mediations are those that can pivot the parties away from the past and toward a future-oriented cost-benefit analysis. The mediator might present a statistical projection. Staying in conflict for another 12 months will likely cost an additional $40,000 in legal fees and expert costs. By contrasting the sunk costs with the potential outcomes of a settlement today, the mediator creates a logical bridge that helps the parties exit the trap. Imagine the scenario of a mid-mediation stalemate over a relatively small asset, like a $5,000 credit card debt or a piece of inherited furniture. In 2026, these small items often become the proxies for the entire failed marriage. The statistical history of mediation shows that these micro-conflicts are often where the most significant breakthroughs happen. When a mediator helps David and Emily resolve a small, symbolic issue using a collaborative framework, it creates a psychological momentum known as the yes ladder. Once the parties say yes to a small resolution, they are statistically more likely to say yes to the larger, more complex financial and custodial agreements later in the day. We must also consider the role of anchoring. The first number put on the table in a negotiation often acts as an anchor, pulling all subsequent counteroffers toward it. In the U.S. litigation system, attorneys often set aggressive anchors to leave room for negotiation, but this historically backfires in mediation by creating a sense of insult or hopelessness. Modern mediation data suggests that a soft anchor approach, where parties discuss ranges based on historical court outcomes rather than hard numbers, leads to more sustainable agreements. The depth of this masterclass requires us to look at the final hour phenomenon. Statistically, more than 60% of mediation settlements in the U.S. occur in the final 20% of the scheduled time. This is known as the deadline effect. As the clock ticks down toward the end of the session, the psychological pressure to reach a resolution intensifies. The brain recognizes that if a deal isn't struck now, the alternative is a return to the high-cost, high-stress world of litigation. Successful mediators use this historical trend to their advantage, often scheduling sessions for a full day to ensure that the parties have enough time to move through the initial resistance and reach that critical settlement window late in the afternoon. While these psychological triggers are universal, there is a specific set of financial data points that act as the hard foundation for every successful mediation in the United States. Without this data, psychology can only take you so far. In the next part, we are going to break down the financial disclosure formula and the 3 specific documents that historically determine whether a mediation succeeds or collapses, including a look at how 2026 tax laws are fundamentally changing the way we calculate the long-term value of a settlement. The financial disclosure formula is the engine room of the mediation process, and in the year 2026, the accuracy of this data is more critical than ever due to the massive shifts in the American tax landscape. Historically, the number one reason mediations failed in the late 20th century was not actually an inability to agree on the kids. It was a fundamental breakdown in financial trust. When one party feels the other is hiding assets or underreporting income, the success rate plummets from 80% to near zero. To maintain the high success rates we see today, mediators rely on 3 specific documents that act as the objective truth of the marriage. These are the sworn financial affidavit, the comprehensive marital balance sheet, and the 5-year lifestyle analysis. The first document, the sworn financial affidavit, is the cornerstone of the entire negotiation. In 2026, this is no longer a simple paper form. Most sophisticated mediation practices in the U.S. now use integrated financial platforms that pull data directly from banking APIs and investment portals to create a real-time snapshot of a family's financial health. Historically, this document required weeks of manual entry, but the digital transition has shortened the disclosure phase by nearly 60%. Imagine a character named Mike, a mid-level executive in Chicago, and his spouse Linda, a freelance consultant. In a 2026 mediation, Mike cannot simply claim he does not know the value of his restricted stock units. The system tracks the vesting schedule and historical price points, providing a neutral data set that both parties must sign under penalty of perjury. This level of transparency is a primary driver behind why mediation has become so much more effective in the last 5 years. The second document is the marital balance sheet. This is where the historical trends of asset division are analyzed against the specific laws of the state, whether it is an equitable distribution state like New York or a community property state like California. The balance sheet does more than just list what the couple owns. It categorizes every item as either marital or separate property. In 2026, the complexity of this task has increased significantly due to the rise of hybrid assets. For Mike and Linda, they might have bought a home using an inheritance Linda received from her grandmother. Historically, this created a massive legal entanglement called commingling. In mediation, instead of spending $20,000 on attorneys to argue about the percentage of equity that belongs to Linda, the parties use the balance sheet to apply historical tracing formulas. By agreeing on the math of the tracing before discussing the distribution, they remove the emotional weight of the decision. The data shows that when couples agree on the characterization of an asset first, they are 75% more likely to agree on its eventual division. The third and perhaps most vital document in the 2026 landscape is the 5-year lifestyle analysis and post-divorce cash flow projection. This is where the rubber meets the road regarding the new tax realities. As of January 2026, many of the provisions from the Tax Cuts and Jobs Act of 2017 have sunset or been modified, meaning the standard deductions and tax brackets for single filers have shifted significantly compared to the last decade. Historically, couples would agree on a support number without fully understanding the net after-tax impact. In 2026, mediation success depends on a deep dive into these projections. For instance, spousal maintenance or alimony is no longer tax-deductible for the payer at the federal level, a trend that began in 2019 but has reached a point of total market saturation by 2026. If Mike pays Linda $5,000 a month, he is paying that with post-tax dollars, and Linda receives it tax-free. Historical case studies show that failing to account for this tax drag is a leading cause of post-divorce financial distress. Mediation solves this by running side-by-side tax simulations for both parties, ensuring that the potential outcomes are sustainable for 2 households instead of 1. We must also look at the historical trend of interest rates and their impact on mediation. In the early 2020s, many American couples were locked into mortgage rates below 3%. By 2026, the cost of refinancing that marital home to buy out a spouse has become a major hurdle. This is where the creativity of mediation creates higher success rates than a court. A judge might simply order the house to be sold, forcing both parties into a high-interest rental market. In mediation, Mike and Linda can explore historical trends like deferred sales or equity sharing agreements. They might decide to keep the existing mortgage in place for 3 years until their youngest child graduates high school, a solution a judge rarely has the authority or the inclination to impose. The flexibility to navigate these high-interest rate environments is a key reason why the data favors mediation for middle-class homeowners in 2026. Let's expand on the concept of the lifestyle analysis. This is not just a budget, it is a forensic look at where the money actually went. In many litigated cases, parties spend months in discovery, subpoenaing credit card statements to prove that one spouse spent too much on hobbies or travel. This is a high-cost, low-reward strategy. In mediation, the lifestyle analysis is used as a neutral tool to determine the actual standard of living. By looking at a 5-year average, the data smooths out the anomalies of a single expensive year or a lean pandemic year. This historical average provides a baseline that is difficult to argue with. When Mike sees that the family historically spent $12,000 a year on children's extracurriculars, It becomes an objective fact to be solved for, rather than a point of contention. The move toward data-driven mediation has also been fueled by the rise of the Certified Divorce Financial Analyst, or CDFA. Historically, mediators were almost exclusively attorneys or mental health professionals. By 2026, the trend has shifted toward a multidisciplinary approach where a financial neutral is brought into the session. The statistics show that when a CDFA is involved in the mediation of high net worth cases, the settlement rate increases by over 15%. This is because the financial neutral can provide immediate, unbiased answers to complex questions about pension valuations, capital gains tax on the sale of a second home, or the long-term impact of inflation on a proposed settlement. For Mike and Linda, having a professional who can run a Monte Carlo simulation on their retirement accounts during the session provides a level of certainty that a courtroom simply cannot match. Furthermore, we must address the step-by-step details of the disclosure process itself. It begins with the initial document dump, followed by a clarification phase where the mediator identifies gaps in the data. Then, a valuation phase occurs where assets like businesses or real estate are appraised. Finally, the negotiation phase begins. The historical success of this sequence relies on the fact that no negotiation happens until the disclosure is 100% complete. Trying to negotiate while the numbers are still shifting is a recipe for failure. In 2026, the most successful mediation participants are those who treat the disclosure phase with the same rigor as a corporate audit. As we look at these financial mechanics, it becomes clear that mediation is not just a conversation, it is a sophisticated financial restructuring. The historical data proves that when the numbers are clear, the path to a deal is usually visible. However, even with perfect financial data and the best tax planning, there is one area where the math often fails and emotions take over with a level of intensity that can derail even the most logical settlement. This is the realm of the parenting plan. While you can divide a bank account down to the penny, you cannot divide a child's life with a calculator. In the next part, we are going to look at the historical success rates of mediated custody agreements and the specific psychological frameworks that allow parents in 2026 to move past their grievances to create a functional co-parenting future. We will explore why the 50-50 custody trend has become a statistical norm across the U.S., and the one specific clause in a parenting plan that historically prevents more future court dates than any other. The statistical shift toward 50-50 custody in the United States represents one of the most significant transformations in family law over the last 50 years. To understand where we are in 2026, we have to look back at the historical trends that brought us here. For much of the 20th century, the American legal system operated under the tender years doctrine, a judicial presumption that favored the mother as the primary caregiver for young children. Statistically, this led to a massive disparity in custodial time, with fathers often relegated to the every other weekend schedule that became the cultural stereotype of the American divorce. However, by the early 2000s, social science data began to overwhelm this outdated model. Longitudinal studies involving thousands of families showed that children in shared parenting arrangements, defined as having at least 35 to 50% time with each parent, demonstrated significantly better outcomes in areas ranging from academic performance to emotional regulation and even long-term physical health. By 2026, this research has translated into a legislative revolution. More than 25 states have now passed laws that either create a rebuttable presumption of equal shared parenting or strongly encourage it. In a mediation setting, this data acts as a powerful baseline. Imagine a couple named Alex and Jordan living in Phoenix, Arizona, in 2026. Arizona was a pioneer in this movement, and the historical data from the state's court system shows that since the implementation of their shared parenting guidelines, the number of contested custody trials has dropped significantly. When Alex and Jordan enter mediation, they are not fighting over who is the better parent in the eyes of a judge. They are working within a statistical framework that recognizes the value of both parents. This shifts the conversation from a win-loss dynamic to a logistical puzzle. How do we make 50-50 work for our specific lives? In this deep dive into the parenting plan, we must examine the math of the calendar. One of the most common hurdles in mediation is the transition fatigue experienced by children. The historical data from family psychologists suggests that the success of a 50-50 plan depends entirely on the transition schedule. For families with younger children, the 2-2-3 schedule is a frequent choice. This means 2 days with parent A, 2 days with parent B, and a 3-day weekend for the first parent, then rotating. While this ensures the child never goes long without seeing either parent, the data shows it can be chaotic for school-age children. By 2026, many mediated agreements for older children have shifted toward the week-on, week-off model, often with a midweek visit. This reduces the number of transitions and allows for a more stable academic week. The key to the high success rates in mediation is the ability to customize these schedules down to the hour, something a court order rarely does with precision. Let us look at a case study regarding the right of first refusal. This is a clause that states if one parent is unavailable during their scheduled time for a certain period, usually 4 to 8 hours, they must offer the other parent the opportunity to watch the child before calling a babysitter. In the litigated world of the 1990s, this clause was often weaponized to track the other parent's movements. However, in 2026, mediation data shows that when the parties define this clause clearly and reasonably, it becomes a major driver of post-divorce cooperation. For Alex and Jordan, they might agree on a 6-hour threshold. This prevents petty arguments over a quick grocery run, but ensures that if Jordan has to travel for work, Alex gets that extra time with the children. The historical trends show that agreements with a well-defined right of first refusal have a 20% higher rate of long-term compliance because they foster a sense of fairness and flexibility. The step-by-step details of creating a mediated parenting plan in 2026 often involve the use of specialized co-parenting technology. Historically, communication was the primary point of failure for divorced parents. The data from 2020 to 2025 showed a direct correlation between the use of centralized communication apps and a reduction in legal filings. In mediation, Alex and Jordan might agree to use a platform that integrates their calendars, tracks expenses, and provides a neutral space for messaging that can be monitored if necessary. By making this technology a requirement of their agreement, they are statistically lowering the probability of future conflict. The mediation success rate remains high because it addresses the communication infrastructure of the future family, rather than just the immediate crisis of the separation. Now we must discuss the specific clause that historically prevents more future court dates than any other: the mandatory dispute resolution clause. This is the magic in the mediation math. This clause stipulates that before either parent can file a motion in court to modify the parenting plan or resolve a disagreement, they must first return to mediation for a minimum of 1 or 2 sessions. The historical impact of this single paragraph is staggering. Data from states like Oregon and Minnesota, which have long traditions of encouraging mediation, show that over 70% of post-divorce disputes are resolved in these follow-up mediation sessions without ever needing a judge. This saves the family thousands in legal fees and prevents the escalation of hostility that occurs the moment a process server shows up at the door. Imagine if Alex and Jordan have a disagreement 2 years from now about which middle school their daughter should attend. In a traditional litigated divorce, one might file a motion, leading to months of stress and thousands in costs. With the dispute resolution clause, they go back to their mediator. The mediator helps them look at the data school rankings, commute times, and the child's preferences within a controlled environment. The historical trend suggests that when parents are forced to talk it out in a neutral setting before they can sue each other, they almost always find a middle ground. This is the structural reason why mediated families stay out of court long after the final decree is signed. We also have to consider the financial intersection of these custody decisions. In 2026, child support in many U.S. jurisdictions is a direct function of the number of overnights. For example, in a state like Illinois or Colorado, there is a specific threshold, often 92 or 146 overnights, where the support calculation shifts from a standard model to a shared care model. This creates a statistical incentive for parents to fight for more time to either receive more support or pay less. Mediation addresses this head-on by decoupling the parenting schedule from the financial calculation in the early stages of the discussion. By focusing on the child's needs first, and then running the numbers second, mediators are able to bypass the financial tug-of-war that often sabotages custody agreements in a courtroom. As we expand on these potential outcomes, we see that the masterclass of mediation is really about the preservation of the co-parenting relationship. The historical data regarding the emotional health of children is clear. It is not the divorce itself that damages children, but the level of conflict they are exposed to. Because mediation reduces that conflict statistically by 80% compared to litigation, it is the superior choice for long-term family stability. We are seeing a 2026 landscape where the warring parents trope is being replaced by the collaborative co-parents data set. However, even with a perfect parenting plan and a solid financial agreement, there is a looming shadow that can cause a mediation to fail at the very last second. It is a document that most people sign without fully understanding, yet it carries the power to undo months of hard work. It is the bridge between the informal agreement and the enforceable court order. In the next part, we are going to look at the Memorandum of Understanding and the final judgment process, specifically exploring the 3 critical errors in wording that historically cause mediated agreements to be rejected by a judge, and how you can ensure your data-driven settlement is bulletproof in the eyes of the court. The transition from the informal atmosphere of a mediation suite to the rigid, binary world of the United States court system is where many successful mediations face their final and most dangerous hurdle. Historically, a successful mediation ends with a document known as the Memorandum of Understanding, or the MOU. In the year 2026, this document is often the result of days or weeks of intense negotiation, reflecting every concession, every trade-off, and every data point we have discussed so far. However, a common misconception among the American public is that the MOU is the final legal word. In reality, the MOU is a non-binding roadmap that must be translated into a formal marital settlement agreement, or MSA, and then incorporated into a final judgment of dissolution of marriage. If this translation is flawed, the high success rates we see in the room can evaporate at the courthouse steps. Statistics from family law courts in major jurisdictions like Los Angeles County and Cook County suggest that approximately 15% of mediated agreements are initially returned by a judge or clerk for corrections. These are not rejections of the settlement itself, but rather rejections of the wording used to describe it. To understand why this happens, imagine a character named Kevin, an engineer in Ohio, and his spouse Maria, a healthcare administrator. After 3 sessions of productive mediation in early 2026, they reached a full agreement. They were relieved, signed their MOU, and thought they were done. However, they fell into the first of the 3 critical errors that historically cause mediated agreements to be rejected or, worse, lead to post-divorce litigation: the reasonable trap. In their MOU, Kevin and Maria agreed that Kevin would have parenting time on weekends and other times as reasonably agreed upon. To a mediator trying to foster goodwill, the word reasonable sounds like a triumph of cooperation. To a judge in 2026, it is an unenforceable nightmare. The historical data on post-divorce conflict shows that when parties are no longer in a state of cooperation, their definitions of reasonable begin to diverge wildly. Does reasonable mean a 2-hour notice or a 2-week notice? Does it mean every weekend or every other weekend? Judges require specificity to ensure they can actually enforce the order if someone violates it. A bulletproof agreement in 2026 must replace reasonable with specific data points. Kevin shall have parenting time every Friday at 5 p.m. until Sunday at 7 p.m., with the exchange occurring at the children's school or a neutral, monitored location. By eliminating ambiguity, you are protecting the integrity of the mediation's success. The second critical error involves the indemnification gap regarding debt and tax liability. In the 2026 financial climate, with complex digital asset portfolios and shifting federal tax codes, many couples agree to divide their debts without specifying who is responsible if a creditor comes calling for the other person's portion. Imagine if Kevin and Maria agreed to split their joint credit card debt 50-50. If Maria fails to pay her half, the creditor, under U.S. contract law, can still legally pursue Kevin for the full amount because both names are on the account. Historically, successful mediated agreements include a robust indemnification clause. This clause states that if one party is forced to pay a debt assigned to the other, the defaulting party must reimburse them, including any legal fees incurred. Without this specific wording, the financial settlement is not truly a final resolution. It is a ticking time bomb. Furthermore, the 2026 tax landscape requires an even higher level of precision. Many couples fail to specify who will claim the children as dependents for the new, adjusted child tax credits. The historical trend in the U.S. has moved toward alternating years or splitting the children if there are multiple, but if the wording in the final decree does not match the specific requirements of the IRS Form 8332, one parent may find themselves facing an audit or a rejected tax return. The data shows that tax-related disputes are one of the top reasons for post-divorce relitigation. A masterclass-level mediation ensures that the final wording doesn't just say they will split the tax benefits, but details exactly which forms will be signed and by what date each year. The third and perhaps most complex error is the unenforceable non-modifiability clause. Many American couples enter mediation wanting a sense of total finality. They want to agree that child support or spousal maintenance will never change, no matter what happens in the future. However, historical trends in U.S. family law, consistently show that you cannot contract away the court's jurisdiction over the best interests of a child. If Kevin loses his high-paying engineering job in 2027, he has a statutory right in most states to request a modification of child support based on a substantial change in circumstances. If the agreement is worded to suggest that child support is absolutely non-modifiable, a judge may strike that entire section of the agreement as being against public policy. The statistical success of mediation depends on creating agreements that are durable, but also legally compliant. This means drafting clauses that acknowledge the state's modification thresholds while setting up private, internal mechanisms, like a return to mediation, to handle those changes before they ever reach a judge. Let us look at a case study of a bulletproof filing from a 2026 perspective. Consider a high-asset couple in Florida. Their final agreement was over 60 pages long. It didn't just list the bank accounts. It listed the last 4 digits of every account, the exact date the transfer of funds would occur, and who was responsible for the wire transfer fees. This level of granular detail is what separates a viral success story from a cautionary tale. The data indicates that the more time spent on the back-end drafting of the MSA, the lower the probability of the parties ever seeing the inside of a courtroom again. In this case, the couple even included a protocol for how to handle future changes in the capital gains tax rate, a proactive move that historical trends show is becoming more common among savvy 2026 participants. Step by step, the path to a bulletproof settlement looks like this. First, the mediator drafts the MOU. Second, each party takes that MOU to an independent consulting attorney, not to start a fight, but to perform a legal audit of the wording. Third, the consulting attorneys translate the MOU into a formal marital settlement agreement that uses the specific terminology required by their local jurisdiction. Finally, the MSA is submitted to the court with a proposed final judgment. In many U.S. states in 2026, this entire process can be handled through an e-filing system, and a judge may sign the decree without the parties ever having to set foot in a physical courtroom. This digital efficiency is only possible when the paperwork is flawless. We must also address the statistical reality of judicial discretion. While judges generally want to approve mediated agreements to clear their dockets, they have a fiduciary duty to ensure the agreement is fair and that children are provided for. If a mediation results in a settlement where one spouse receives 0 assets and the other receives everything, the judge may reject it on the grounds of unconscionability. The historical data from 2024 and 2025 shows that judges are becoming more scrutinized in their review of these agreements to prevent instances of coerced settlements. Therefore, the wording of the agreement must often include a statement that both parties have had the opportunity to consult with legal counsel, and that they believe the agreement to be a fair and equitable resolution of their marital issues. The depth of this process reveals that the true success of mediation is found in the intersection of human psychology and precise legal engineering. You are not just settling a dispute, you are drafting a private constitution for your future life. The historical trends prove that those who treat the drafting phase with the same intensity as the negotiation phase are the ones who truly benefit from the mediation process. But even with a perfect, bulletproof legal document in hand, there is a variable that the paperwork cannot control. This variable exists inside the minds of the participants long after the ink has dried. It is the phenomenon of settlement remorse, and it is the primary reason why some people try to overturn their agreements months later. In the next part, we will explore the remorse rate statistics and the 3 specific steps you can take during the mediation itself to ensure that your yes stays a yes, and that your data-driven settlement survives the emotional turbulence of the post-divorce transition. We will look at why the first 48 hours after signing are the most critical for the long-term viability of the deal. The phenomenon of settlement remorse is a documented psychological state that occurs when the high-intensity environment of a successful negotiation suddenly gives way to the quiet reality of everyday life. In the professional world of U.S. mediation, we call this the decompression period. Historically, the first 48 hours after a couple signs their memorandum of understanding are the most volatile. This is because the brain is transitioning from a state of hypervigilance and survival-based negotiation into a state of reflection. In 2026, the data indicates that while 82% of mediations result in an agreement, approximately 12% of participants experience a significant wave of regret within the first 2 days. Understanding why this happens is the key to ensuring that the potential outcomes of your mediation remain stable for years to come. Imagine a character named Mark, a project manager in Charlotte, North Carolina, and his spouse Sophia, a specialized nurse. They have just completed a grueling 10-hour mediation session in June 2026. They reached an agreement on their complex equity split and a rotating holiday schedule for their 2 children. In the room, Mark felt a sense of immense relief. He felt that the deal was fair and that he could finally move on. However, the moment he stepped out of the mediator's office and drove home, the silence of his car allowed his mind to start second-guessing every concession he made. This is the biological reality of settlement remorse. When the dopamine of reaching a resolution fades, the cortisol of perceived loss takes over. The first major driver of this remorse is what we call the kitchen cabinet effect. This is a historical trend where a party who was satisfied with the deal in the room goes home and presents the settlement to a close friend, a family member, or a new romantic partner. In Mark's case, he called his brother, who immediately began critiquing the deal. His brother, who is not a legal professional and does not understand the specific trade-offs made during the 10-hour session, tells Mark that he got robbed on the equity split. Statistically, this external influence is the #1 reason why people attempt to retract their signature or refuse to sign the final formal documents. The historical data from 2024 and 2025 suggests that parties who do not set boundaries with their social circle during the first 48 hours are 40% more likely to experience settlement remorse. To counter this, a professional mediation masterclass in 2026 teaches 3 specific steps to prevent this psychological collapse. The first step is the anchor to the alternative, also known as the BATNA, the best alternative to a negotiated agreement. During the mediation, a skilled mediator will have Mark and Sophia explicitly document what the alternative would have looked like if they did not settle. For Mark, the alternative was a 3-day trial in 6 months, another $30,000 in legal fees, and the risk of a judge who might have given him even less equity. Historically, when a party feels remorse, the most effective cure is to look at the math of the alternative. By comparing the mediated deal not to a perfect fantasy, but to the cold, hard reality of a courtroom, the remorse typically dissipates. The second step is the use of a cooling-off period clause. In many high-stakes U.S. mediations in 2026, the Memorandum of Understanding includes a specific provision that allows for a 24 to 48-hour period where the parties can review the document with their respective attorneys before it becomes an irrevocable contract. While this might seem counterintuitive to reaching a final deal, the historical trends show that agreements with a built-in cooling-off period actually have a higher long-term compliance rate. It allows Mark and Sophia to sleep on the decision, speak to their counsel, and approach the deal with a clear head. When they choose to stay with the deal after the adrenaline has subsided, the commitment to the agreement becomes much deeper. The third step involves a technique called the comprehensive finality check. This is a step-by-step detail-oriented review conducted at the very end of the mediation session. Before anyone leaves the room or closes the laptop, the mediator reads back every single point of the agreement. For Mark and Sophia, this meant going over the exact dates of the summer vacation, the specific bank account numbers, and the division of the small sentimental items like the family photo albums. The data shows that remorse often stems from a feeling of being rushed or missing a small detail. By spending an extra 30 minutes at the end of a long day to verify every line item, the mediator helps the parties build a sense of psychological ownership over the deal. Historically, this reduces the remorse rate by nearly 60%. We also have to look at the statistical success of those who actually try to overturn a mediated agreement in the U.S. court system. In 2026, the legal bar for set-aside motions, the formal request to a judge to throw out a signed settlement, is incredibly high. Historically, you cannot overturn an agreement just because you changed your mind or realized you could have gotten a better deal. You must prove things like fraud, duress, or unconscionability. The data from 2025 shows that less than 2% of these motions are successful in cases where the parties were represented by counsel, or where the mediation was conducted by a certified professional. For someone like Mark, knowing that the deal is legally robust, and that the court respects the mediation process acts as a powerful deterrent to impulsive regret. Let's look at a case study of a high-conflict mediation in 2026 that almost collapsed due to remorse. A couple in Texas had agreed to a complex business valuation and a tiered alimony structure. The husband, after signing the MOU, attempted to claim he was under duress because the session lasted until 9 p.m. and he was tired. The court looked at the historical trends and the mediator's detailed notes, which showed that the husband had taken multiple breaks, had eaten dinner, and had consulted with his attorney 3 times during the final hour. The judge denied the motion to set aside the agreement, citing that being tired is not the same as being under legal duress. This case serves as a warning and a lesson for the U.S. audience. The time to be careful is in the room, not after you leave. The depth of this masterclass requires us to acknowledge that some level of regret is a normal part of the human experience when ending a marriage. It is a major life transition, and no agreement is perfect. However, by using the 2026 data-driven approach to mediation, you are shifting the probability in your favor. You are moving from a state of emotional reaction to a state of strategic resolution. The historical trends prove that the most successful participants are those who treat the settlement as a business transaction, one that allows them to preserve their wealth, their sanity, and their relationship with their children. As we move forward, we must realize that while these steps work for most people, there is a specific category of individuals who represent a major statistical outlier. These are the cases where one party has no intention of settling in good faith, or where a personality disorder makes the standard rules of negotiation obsolete. For the U.S. audience in 2026, the rise of the high-conflict personality in the legal system is a major concern. In the next part, we are going to dive into the statistics of mediating with a narcissist or a high-conflict individual. We will explore the specific tactical adjustments mediators use to reach an 80% success rate, even when one party is determined to win at all costs, and the one specific type of mediation model that is historically the only way to handle these volatile situations. The specific type of mediation model that has historically transformed the success rates for high-conflict cases in the United States is known as the parallel mediation model, or more commonly in the 2026 legal landscape, the neutral buffer protocol. To understand why this is the only viable path for volatile situations, we have to look at the statistical profile of what the American legal system classifies as a high-conflict personality, or HCP. Research from the High Conflict Institute and various family court studies across the U.S. indicates that while HCPs represent only about 15% of the general population, they are involved in over 90% of the cases that reach the level of a contested trial. Historically, traditional mediation, where two people sit in a room and try to find common ground, has a failure rate of nearly 60% when an HCP is involved. However, when the model shifts to parallel mediation, the settlement success rate climbs back up toward that 80% threshold. In 2026, the math of conflict has changed. Imagine a character named Chloe, a marketing director in Denver, and her spouse Ryan, who has spent years in a high-pressure corporate environment and exhibits the classic traits of an HCP. Ryan does not view the divorce as a reorganization of assets. He views it as a zero-sum game where there must be a winner and a loser. In a traditional 2010-era mediation, Ryan would use the session as a platform for what psychologists call narcissistic supply, using every moment to blame Chloe for the breakdown of the marriage. This would inevitably lead to an emotional collapse of the session within the first hour. In the 2026 parallel mediation model, Chloe and Ryan never see each other, nor do they hear each other's voices. This is not just shuttle diplomacy, it is a data-isolated negotiation. The mediator acts as a biological firewall. The step-by-step details of this process begin with the separate intake sessions. The mediator identifies the specific triggers that Ryan uses to derail the conversation. Historically, HCPs use three primary tactics: blaming, emotional storytelling, and all-or-nothing thinking. By identifying these early, the mediator can apply the BIF method, brief, informative, friendly, and firm, to every piece of information that passes between the rooms. Let us look at a case study involving a complex asset division for this couple. Ryan believes he should keep 70% of the marital home's equity because he provided the initial down payment 10 years ago, despite Colorado being an equitable distribution state where marital contributions are viewed holistically. In a courtroom, this argument would take 2 days and cost $20,000 in legal fees to resolve. In the parallel mediation model, the mediator takes Ryan's demand and strips away the emotional justification. Instead of telling Chloe, Ryan thinks he deserves more because he paid the down payment, the mediator presents a range of historical settlement trends for similar cases in the Denver area. By removing the personal attack, the mediator prevents Chloe from going into a defensive, reactive state. The success of this model is rooted in the statistical concept of the neutral buffer. In 2026, many mediators are using advanced linguistic software to analyze the tone of the proposals. Historical data suggests that when a proposal contains words like always, never, or you should, the rejection rate is nearly 85%. When the mediator reframes the proposal into a neutral financial data point, such as, A 60-40 split would result in a net liquidity of $400,000 for each party. The acceptance rate increases by over 40%. This is because the HCP, like Ryan, is forced to engage with the math rather than the person they are trying to defeat. We also have to address the role of digital disclosure in high-conflict cases. Historically, HCPs have been able to weaponize financial information, either by withholding it or by flooding the other party with thousands of irrelevant documents to create a state of decision paralysis. In 2026, the U.S. mediation industry has largely adopted automated financial forensics. For Chloe and Ryan, this means the mediator uses a secure portal that aggregates all their financial data directly from the source. The statistics show that when an HCP knows the data is being pulled via API and cannot be manipulated, the rate of financial transparency increases by 65% compared to manual disclosure models. This effectively shuts down the hide-and-seek game that often leads to mediation failure. However, the 20% of cases that still fail in this model usually do so because of what is known as litigation addiction. This is a historical trend where one party derives a psychological benefit from the conflict itself. For these individuals, the cost of the attorney is less important than the continuation of the battle. The data shows that in these specific cases, the only way to reach a settlement is through a technique called the final offer format. This is where, after a set number of hours, the mediator requires both parties to submit their absolute best and final offer on a specific issue. If the offers are within a 10% margin of each other, the mediator uses a historical settlement formula to bridge the gap. In 2026, this approach has saved thousands of families from the scorched earth litigation that used to be the only option for high-conflict couples. Imagine if Chloe and Ryan were fighting over the custody of their teenage son. Ryan wants to use the custody schedule to punish Chloe for leaving. The mediator introduces a child-centered consultant, a trend that has grown by 50% in the last decade of U.S. family law. This consultant provides a data-driven report on what a 2-2-5-5 schedule looks like for a child of that specific age and academic profile. Because the data comes from a neutral expert and not from Chloe, Ryan's historical tendency to reject anything Chloe suggests is bypassed. The probability of him agreeing to a shared parenting plan increases because he perceives the expert as a neutral authority rather than an adversary. The depth of the parallel mediation model also includes the management of the lawyer's role. In high-conflict cases, attorneys can sometimes act as fire starters rather than fire extinguishers. The statistical history of successful 2026 mediations shows a preference for attorneys who are specifically trained in collaborative law. These professionals understand that their goal is not to win the mediation, but to facilitate a settlement that is durable. When both parties are represented by settlement-focused counsel, the rate of successful mediation for HCP cases jumps an additional 15%. This brings us to the reality of the final decree for a high-conflict couple. The wording must be incredibly precise. In Ryan and Chloe's case, the agreement cannot just say they will share holiday time. It must specify the exact minute of the exchange, the exact GPS coordinates of the drop-off, and the specific method of communication, such as a court-monitored app. The historical data proves that ambiguity is the fuel for high-conflict relitigation. By using mediation to create a highly structured, low-contact environment, these families are statistically able to transition into a functional, if distant, co-parenting relationship. The lesson for the U.S. audience here is that no matter how difficult the other person may be, the numbers show that mediation is still a mathematically superior choice compared to a trial. You are not betting on the other person's goodness. You are betting on a structured process that is designed to neutralize their worst impulses. We have seen how the history of mediation has moved from a simple conversation to a sophisticated, data-driven system of conflict management. But even after the conflict is managed and the agreement is signed, there is one final hurdle that determines if the settlement actually changes the lives of the parties involved. It is the phase where the numbers on a piece of paper become the reality of a new bank account and a new home. In the next part, we are going to look at the implementation statistics and the post-mediation audit. We will explore why 30% of settlements fail during the asset transfer phase, and the 3 specific steps you must take in the first 90 days after your divorce is final to ensure your mediated success isn't just a statistical anomaly, but a permanent financial foundation. We will look at the rise of the divorce implementation specialist in 2026, and how they are closing the gap between a signed deal and a secure future. The implementation gap is the silent killer of even the most successful mediations in the United States. Historically, the signing of the final judgment is treated as the finish line, but the data suggests it is actually the beginning of the most high-risk phase of the entire process. Statistics from 2024 and 2025 reveal that approximately 30% of mediated settlements fail to be fully executed within the first 12 months. This failure does not usually stem from a lack of desire to comply, but from a lack of a technical roadmap for the actual transfer of assets. In the year 2026, the complexity of modern financial lives, spanning across digital brokerage accounts, multi-state real estate holdings, and tiered retirement vehicles, has made the implementation phase a specialized field of its own. To visualize this, imagine a character named James, a senior software architect living in suburban Chicago in 2026. James and his ex-spouse completed their mediation in January, reaching a comprehensive agreement on their $3 million marital estate. They had a signed court order, they shook hands, and they moved into separate residences. However, 6 months later, James is sitting at his kitchen table realizing that none of the retirement funds have actually moved. The title to the family SUV is still in both names, and he is receiving late payment alerts for a joint credit card he thought was closed. This is the reality for thousands of Americans who rely on the paper decree without a post-mediation audit. The primary technical hurdle in this phase is the Qualified Domestic Relations Order, or QDRO. Historically, this is one of the most misunderstood documents in the U.S. legal system. A divorce decree can state that a spouse is entitled to 50% of a 401k, but that decree is legally insufficient to compel a plan administrator to move the money. Because retirement accounts are governed by federal ERISA laws, a separate, highly technical order must be drafted, approved by the plan administrator, and signed by a judge. In 2026, the data shows that 1 in 5 QDROs are rejected on the first submission due to minor clerical errors or outdated plan language. For James, the failure to file a QDRO immediately meant that when the market shifted in the spring of 2026, the valuation of the account changed, leading to a new dispute over whether his ex-spouse was entitled to a specific dollar amount or a percentage of the now fluctuated balance. Historical trends suggest that the most successful mediations are those that have a QDRO expert pre-approve the language before the mediation is even finished. Beyond retirement, we must analyze the 2026 real estate market and its impact on implementation. In the early 2020s, many couples were holding mortgages with interest rates as low as 2 or 3%. By 2026, the statistical reality is that refinancing that home to remove a spouse from the deed has become a massive financial burden. If James agreed to buy out his spouse's equity, he is likely looking at a new mortgage rate that could be double or triple his original rate. This creates what we call the equity trap. Historical case studies from 2025 show a spike in parties returning to mediation because the buyout they agreed to is no longer financially viable under current lending standards. A data-driven implementation plan in 2026 must include a pre-qualification letter from a lender to ensure the potential outcomes of the settlement are actually achievable in the real world. This brings us to the rise of the Divorce Implementation Specialist, or DIS. This is a professional role that has gained significant traction in the U.S. over the last 3 years. The DIS acts as a project manager for the divorce. Their job is to take the 70-page settlement agreement and turn it into a checklist with hard deadlines. The statistics regarding the use of a DIS are compelling. Historical data from 2025 indicates that couples who engage an implementation specialist have a 95% completion rate of asset transfers within the first 90 days, compared to only 60% for those who attempt to navigate the bureaucracy alone. For James, a DIS would have coordinated with the title company, the bank, and the HR department to ensure every box was checked. The post-mediation audit is a 3-step process designed to protect the integrity of the settlement. The first step is the account closure and credit protection phase. Statistically, post-divorce credit score drops are often linked to joint accounts that were left open and forgotten. In 2026, with the prevalence of automated subscriptions and digital wallets, the task of decoupling finances is more granular than ever. James should have a step-by-step detail of every recurring payment. The historical trend in successful cases is to close all joint accounts and open new, individual accounts on the same business day to ensure there is no gap in coverage for essential bills or insurance premiums. The second step of the audit involves beneficiary designations. This is a critical area where historical trends show significant litigation risk. In many U.S. states, a divorce decree automatically revokes a spouse's status as a beneficiary on a life insurance policy or a bank account. However, this is not a universal rule and does not apply to all types of policies. If James were to pass away in late 2026 without updating his designations, his ex-spouse and his current estate could end up in a multi-year legal battle over the proceeds. The implementation data suggests that a successful transition requires a certified mail notification to every insurance carrier and financial institution within 30 days of the final decree. The third step is the 90-day liquidation rule. Historically, items like the sale of a vacation home or the liquidation of a joint brokerage account are the areas where procrastination is most common. The data shows that if an asset is not listed for sale or liquidated within the first 90 days, the probability of it becoming a point of new litigation increases by 50%. By 2026, many mediated agreements include a self-executing clause, which states that if an asset is not moved by a certain date, a third-party receiver is automatically appointed to handle the sale. This creates a statistical incentive for both parties to stay on schedule. We also have to consider the emotional tax of the implementation phase. After the intensity of mediation, many people experience a form of decision fatigue. They simply want the process to be over, leading them to cut corners on the paperwork. However, the potential outcomes of cutting these corners can be devastating. For a character like Sarah in Austin, Texas, failing to properly execute a quitclaim deed on a rental property in 2026 meant she was still legally liable when a tenant was injured on the property months after the divorce. The historical record is full of these stories where the lack of follow-through turned a successful mediation into a legal nightmare. By following the 2026 implementation protocols, you are essentially insulating your future self from the errors of the past. You are treating the settlement not as a suggestion, but as a business merger that requires a formal integration plan. The depth of this masterclass is intended to show you that the math of mediation doesn't end when the judge signs the paper. It ends when the last dollar is moved and the last title is transferred. We have spent 9 parts looking at the history, the psychology, and the financial mechanics of how we get to a deal. The data is clear: mediation is the most efficient, cost-effective, and sustainable way to end a marriage in the United States today. But there is one final piece of the puzzle. As we look toward the end of 2026 and into the future, the technology of mediation is undergoing a radical change. We are moving toward a world where the statistics we have discussed will be enhanced by a new layer of intelligence. In the final part of this masterclass, we are going to look at the grand statistical summary and the future of resolution. We will explore how AI-driven predictive modeling is beginning to anticipate conflicts before they happen, and the one final takeaway that will determine your personal success rate in the new era of American family law. This is the synthesis of everything we have learned, applied to the horizon of tomorrow. As we stand in the landscape of 2026, the synthesis of half a century of mediation data reveals a startling conclusion. We have moved beyond the era of experimental conflict resolution into the era of resolution intelligence. The one final takeaway that will determine your personal success rate in this new era is the shift from being a spectator of your legal battle to being the architect of your own information. Historically, the participants who achieve the most sustainable potential outcomes are those who view their divorce not as a series of legal demands, but as a data-driven restructuring of a family's financial and emotional infrastructure. In this final part of our masterclass, we are going to look at the grand statistical summary of the last 50 years and the technological horizon that is fundamentally changing how Americans resolve disputes. To understand the horizon of tomorrow, we must first look at the massive arc of history that led us to 2026. In 1976, the concept of mediation was a radical alternative at the periphery of the U.S. legal system. By 1996, it was a tool for court efficiency. By 2016, it was a preferred method for high-net-worth individuals. Today, in 2026, mediation is the primary economic engine of the family law system. The historical trends show that the U.S. litigation industry, once a $250 billion machine fueled by conflict, is being disrupted by a $75 billion mediation and collaborative services sector. This shift is not just cultural, it is mathematical. The data from 2020 to 2026 shows that for every dollar that left the adversarial litigation system and moved toward mediation, the velocity of wealth transfer to the next generation increased by 30%. This is because assets were not being drained by legal fees, but were instead being repositioned for the future. Imagine a character named Elena, a biotechnology researcher in San Diego, and her spouse Marcus, a freelance creative director. In late 2026, they are using what is now becoming common in major U.S. cities: a resolution dashboard. This is the evolution of the mediation process we have been discussing. Instead of relying on static documents, Elena and Marcus are plugged into a predictive modeling system that uses historical data from thousands of similar cases in Southern California to project settlement ranges. Historically, the uncertainty of what a judge might do was the primary driver of fear. In 2026, the data has removed that shadow. The dashboard shows them that based on their income, their children's ages, and their assets, there is an 85% probability that a judge would award a specific range of support. This historical transparency acts as a powerful gravitational pull toward the center, allowing them to reach a deal in 2 sessions that would have taken 2 years in 1990. The success rate of this AI-integrated mediation in 2026 is trending even higher than the traditional 80% we have cited throughout this series. Initial data from 2025 pilot programs suggest that when parties have access to real-time predictive modeling, the settlement rate climbs toward 92%. This is because it is much harder to maintain an unreasonable position when a computer model, backed by 10 years of court data, shows that your position has a less than 5% chance of being upheld in a trial. For Elena and Marcus, this meant they could bypass the posturing phase and move straight to the solution phase. Step by step, they spent their sessions not arguing about the law, but fine-tuning the nuances of their co-parenting plan and the timing of their asset liquidations. We must also look at the longitudinal data concerning the children of these mediated divorces. As we reach the midpoint of this decade, we are seeing the results of the first generation of children raised entirely under the 2010s era shared parenting mediation models. The statistics are profound. Children from mediated families in the U.S. are 40% more likely to complete a 4-year college degree and 30% less likely to experience a divorce of their own by age 30. This suggests that mediation is not just a legal shortcut. It is a mechanism for breaking the intergenerational cycle of high-conflict family dissolution. By witnessing their parents resolve a crisis through negotiation rather than litigation, these children learned a model for conflict resolution that they carried into their own lives. The economic impact of this historical shift cannot be overstated. In 2026, the American workforce is more mobile and more gig-oriented than ever. Traditional litigation models were built for the 1950s: one primary earner, one house, one pension. That world is gone. Mediation is the only system flexible enough to handle the 2026 reality of side hustles, remote work, and digital assets. The potential outcomes of a mediated settlement in 2026 often include clauses for the future valuation of social media channels, the management of shared digital royalties, and the division of carbon credit portfolios. The historical data proves that judges, who are often bound by rigid statutes, struggle to keep pace with these modern financial complexities. Mediation, however, thrives on this complexity, allowing for creative trade-offs that simply do not exist in a courtroom. Let us look at a case study of a high-tech 2026 mediation success. A couple in Austin, Texas, had a disagreement over the future value of a private equity investment that wouldn't vest for 5 years. Instead of fighting over a present-day valuation that would have been a guess at best, they used their mediator to draft a smart contract in their settlement agreement. This contract, written into the legal decree, automatically triggers a specific percentage transfer of funds the moment the vest occurs in 2031, adjusted for the tax rates of that future year. This level of sophistication is the hallmark of the 2026 Mediation Masterclass. It effectively eliminates the need for any future contact between the parties regarding that asset. The data shows that these self-executing clauses have reduced post-divorce litigation by an additional 15% in the jurisdictions where they are legal. The final takeaway for you as a participant in this modern system is the power of agency. In every part of this 10-part series, from the initial hook to this grand summary, the recurring theme has been that the math favors the prepared. The historical trends show that the participants who get the best results are not the ones with the loudest attorneys, but the ones with the cleanest data and the most realistic expectations. By understanding the psychology of loss aversion, the mechanics of financial disclosure, and the importance of the implementation phase, you are positioning yourself within that 80% success bracket. As we conclude this deep dive, we have to recognize that we are at the dawn of what some legal scholars are calling Divorce 3.0. This is an era where the boundary between mediation and the courtroom is becoming even more defined. We are seeing the rise of private, digital courtrooms where mediated agreements are processed and finalized in minutes by a specialized magistrate who deals only with uncontested settlements. The efficiency of the U.S. family law system is undergoing a total transformation, and the winners are the families who choose the path of collaboration. However, even as we master the statistics of today, a new set of challenges is appearing on the horizon. The way we think about family structure, asset ownership, and legal identity is continuing to evolve at a rapid pace. While this series has provided the definitive historical and mathematical guide to mediation in 2026, the question remains: how will these systems adapt to the even more complex realities of the 2030s? In our upcoming special bonus masterclass, we will explore the resolution frontier, diving into the emerging data on global cross-border mediation and the rise of decentralized family law. You have the data, you have the history, and you have the tools. Now the future of your resolution is in your hands.